We continue with the opinion of the court in Trump v. United States, picking up with Part 3 of the opinion on page 16. Part 3. Determining whether a former president is entitled to immunity from a particular prosecution requires applying the principles we have laid out to his conduct at issue. The first step is to distinguish his official from unofficial actions. In this case, however, no court has thus far considered how to draw that distinction, in general or with respect to the conduct alleged in particular. Despite the unprecedented nature of this case, and the very significant constitutional questions that it raises, the lower courts rendered their decisions on a highly expedited basis. Because those courts categorically rejected any form of presidential immunity, they did not analyze the conduct alleged in the indictment to decide which of it should be categorized as official and which unofficial. Neither party has briefed that issue before us, though they discussed it at oral argument in response to questions. And like the underlying immunity question, that categorization raises multiple unprecedented and momentous questions about the powers of the president and the limits of his authority under the Constitution. As we have noted, there is little pertinent precedent on those subjects to guide our review of this case, a case that we too are deciding on an expedited basis, less than 5 months after we granted the government's request to construe Trump's emergency application for a stay as a petition for certiorari. Grant that petition and answer the consequential immunity question. Given all these circumstances, it is particularly incumbent upon us to be mindful of our frequent admonition that ours is a court of final review and not first view. Critical threshold issues in this case are how to differentiate between a president's official and unofficial actions, and how to do so with respect to the indictment's extensive and detailed allegations covering a broad range of conduct. We offer guidance on those issues below. Certain allegations, such as those involving Trump's discussions with the acting Attorney General, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations and determining whether they are subject to immunity, that analysis ultimately is best left to the lower courts to perform in the first instance. Section A. Distinguishing the president's official actions from his unofficial ones can be difficult. When the president acts pursuant to the constitutional and statutory authority, he takes official action to perform the functions of his office. Determining whether an action is covered by immunity thus begins with assessing the president's authority to take that action. But the breadth of the president's discretionary responsibilities under the Constitution and laws of the United States in a broad variety of areas, many of them highly sensitive, frequently makes it difficult to determine which of his innumerable functions encompassed a particular action. And some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official even when not obviously connected to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the President's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. In dividing official from unofficial conduct, courts may not inquire into the President's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. Indeed, it would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of the government if, in exercising the functions of his office, the President was under an apprehension that the motives that control his official conduct may at any time become the subject of inquiry. We thus rejected such inquiries in Fitzgerald. The plaintiff there contended that he was dismissed from the Air Force for retaliatory reasons. The Air Force responded that the reorganization that led to Fitzgerald's dismissal was undertaken to promote efficiency. Because under Fitzgerald's theory, an inquiry into the President's motives could not be avoided, we rejected the theory, observing that inquiries of this kind could be highly intrusive. Bare allegations of malice should not suffice to subject government officials either to the costs of trial or to the burdens of broad-reaching discovery. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. For instance, when Fitzgerald contended that his dismissal violated various congressional statutes and thus rendered his discharge outside the outer perimeter of Nixon's duties, we rejected that contention. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. Section B. With these principles in mind, we turn to the conduct alleged in the indictment. 1. The indictment broadly alleges that Trump and his co-conspirators sought to overturn the legitimate results of the 2020 presidential election. It charges that they conspired to obstruct the January 6th congressional proceeding at which electoral votes are counted and certified, and the winner of the election is certified as president-elect. As part of this conspiracy, Trump and his co-conspirators allegedly attempted to leverage the Justice Department's power and authority to convince certain states to replace their legitimate electors with Trump's fraudulent slates of electors. According to the indictment, Trump met with the acting Attorney General and other senior Justice Department and White House officials to discuss investigating purported election fraud and sending a letter from the department to those states regarding such fraud. The indictment further alleges that after the acting Attorney General resisted Trump's requests, Trump repeatedly threatened to replace him. The government does not dispute that the indictment's allegations regarding the Justice Department involve Trump's use of official power. The allegations, in fact, plainly implicate Trump's conclusive and preclusive authority. Investigation and prosecution of crimes is a quintessentially executive function, and the executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute, including with respect to allegations of election crime. The President may discuss potential investigations and prosecutions with his Attorney General and other Justice Department officials to carry out his constitutional duty to take care that the laws be faithfully executed. And the Attorney General, as head of the Justice Department, acts as the President's chief law enforcement officer who provides vital assistance to him in the performance of his constitutional duty to preserve, protect, and defend the Constitution. Investigative and prosecutorial decision-making is the special province of the executive branch, and the Constitution vests the entirety of the executive power in the President. For that reason, Trump's threatened removal of the acting Attorney General likewise implicates conclusive and preclusive presidential authority. As we have explained, the President's power to remove executive officers of the United States whom he has appointed may not be regulated by Congress or reviewed by the courts. The President's management of the executive branch requires him to have unrestricted power to remove the most important of his subordinates, such as the Attorney General, in their most important duties. The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the President of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials. 2. The indictment next alleges that Trump and his co-conspirators attempted to enlist the Vice President to use his ceremonial role at the January 6th certification proceeding to fraudulently alter the election results. In particular, the indictment alleges several conversations in which Trump pressured the Vice President to reject states' legitimate electoral votes or send them back to state legislatures for review. The government explained at oral argument that although it has not yet had to come to grips with how it would analyze Trump's interactions with the Vice President, there is support to characterize that conduct as official. Indeed, our constitutional system anticipates that the President and Vice President will remain in close contact regarding their official duties over the course of the President's term in office. These two officials are the only ones elected by the entire nation. The Constitution provides that the Vice President shall become President in the case of the removal of the President from office or of his death or resignation. It also empowers the Vice President, together with a majority of the principal officers of the executive departments, to declare the President unable to discharge the powers and duties of his office. And Article 1, of course, names the Vice President as President of the Senate and gives him a tie-breaking vote. It is thus important for the President to discuss official matters with the Vice President to ensure continuity within the executive branch and to advance the President's agenda in Congress and beyond. The Vice President may in practice also serve as one of the President's closest advisors. The Office of Legal Counsel has explained that within the executive branch, the Vice President's sole function is advising and assisting the President. Indeed, the 12th Amendment was brought about to avoid the manifestly intolerable situation that occurred during the John Adams administration, when we had a president and a vice president of different parties. The president and vice president together are the senior officials of the executive branch of government, and therefore must formulate, explain, advocate, and defend policies of the President's administration. As the president's second in command, the vice president has historically performed important functions at the will and as the representative of the president. President Woodrow Wilson's vice president, for instance, presided over a few cabinet meetings while Wilson was in France negotiating the Treaty of Versailles after World War I. During President Franklin Roosevelt's administration, the vice president became a regular participant in cabinet deliberations, a practice that was continued by each succeeding president. And when President Dwight Eisenhower suffered 3 major illnesses while in office, Vice President Richard Nixon consulted with the cabinet and developed a procedure for relaying important matters to the president. At the president's discretion, the vice president may engage in activities ranging into the highest levels of diplomacy and negotiation, and may do so anywhere in the world. Domestically, he may act as the president's delegate to perform any duties coextensive with the scope of the president's power of delegation. Whenever the president and vice president discuss their official responsibilities, they engage in official conduct. Presiding over the January 6th certification proceeding at which members of Congress count the electoral votes is a constitutional and statutory duty of the vice president. The indictment's allegations that Trump attempted to pressure the vice president to take particular acts in connection with his role at the certification proceeding thus involve official conduct, and Trump is at least presumptively immune from prosecution for such conduct. The question then becomes whether that presumption of immunity is rebutted under the circumstances. When the vice president presides over the January 6th certification proceeding, he does so in his capacity as President of the Senate. Despite the vice president's expansive role of advising and assisting the president within the executive branch, the vice president's Article I responsibility of presiding over the Senate is not an executive branch function. With respect to the certification proceeding in particular, Congress has legislated extensively to define the vice president's role in the counting of the electoral votes, and the president plays no direct constitutional or statutory role in that process. So the government may argue that consideration of the president's communications with the vice president concerning the certification proceeding does not pose dangers of intrusion on the authority and functions of the executive branch. At the same time, however, the president may frequently rely on the vice president in his capacity as president of the Senate to advance the president's agenda in Congress. When the Senate is closely divided, for instance, the vice president's tie-breaking vote may be crucial for confirming the president's nominees and passing laws that align with the president's policies. Applying a criminal prohibition to the president's conversations discussing such matters with the vice president, even though they concern his role as president of the Senate, may well hinder the president's ability to perform his constitutional functions. It is ultimately the government's burden to rebut the presumption of immunity. We therefore remand to the district court to assess in the first instance, with appropriate input from the parties, whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding in his capacity as president of the Senate would pose any dangers of intrusion on the authority and functions of the executive branch. 3. The indictment's remaining allegations cover a broad range of conduct. Unlike the allegations describing Trump's communications with the Justice Department and the Vice President, these remaining allegations involve Trump's interactions with persons outside the executive branch, state officials, private parties, and the general public. Many of the remaining allegations, for instance, cover at great length events arising out of communications that Trump and his co-conspirators initiated with state legislators and election officials in Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin regarding those states' certification of electors. Specifically, the indictment alleges that Trump and his co-conspirators attempted to convince those individuals that election fraud had tainted the popular vote count in their states, and thus electoral votes for Trump's opponent needed to be changed to electoral votes for Trump. After Trump failed to convince those officials to alter their state processes, he and his co-conspirators allegedly developed a plan to marshal individuals who would have served as Trump's electors had he won the popular vote in Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin, and cause those individuals to make and send to the Vice President and Congress false certifications that they were legitimate electors. If the plan worked, the submission of these fraudulent slates would position the Vice President to open and count the fraudulent votes at the certification proceeding and set up a fake controversy that would derail the proper certification of Biden as president-elect. According to the indictment, Trump used his campaign staff to effectuate the plan. On the same day that the legitimate electors met in their respective jurisdictions to cast their votes, the indictment alleges that Trump's fraudulent electors convened sham proceedings in the 7 targeted states to cast fraudulent electoral ballots in his favor. Those ballots were mailed to the President of the Senate, the Archivist of the United States, and others. At oral argument, Trump appeared to concede that at least some of these acts, those involving private actors who helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding at the direction of Trump and a co-conspirator, entail private conduct. He later asserted, however, that asking the chairwoman of the Republican National Committee to gather electors qualifies as official conduct because the organization of alternate slates of electors is based on, for example, the historical example of President Grant as something that was done pursuant to and ancillary and preparatory to the exercise of a core presidential power. He also argued that it is absolutely an official act for the president to communicate with state officials on the integrity of a federal election. The government disagreed, contending that this alleged conduct does not qualify as official conduct, but as campaign conduct. On Trump's view, the alleged conduct qualifies as official because it was undertaken to ensure the integrity and proper administration of the federal election. Of course, the president's duty to take care that the laws be faithfully executed plainly encompasses enforcement of federal election laws passed by Congress. And the president's broad power to speak on matters of public concern does not exclude his public communications regarding the fairness and integrity of federal elections simply because he is running for re-election. Similarly, the president may speak on and discuss such matters with state officials, even when no specific federal responsibility requires his communication, to encourage them to act in a manner that promotes the president's view of the public good. As the government sees it, however, these allegations encompass nothing more than Trump's private scheme with private actors. In its view, Trump can point to no plausible source of authority enabling the president to not only organize alternate slates of electors, but also cause those electors, unapproved by any state official, to transmit votes to the President of the Senate for counting at the certification proceeding, thus interfering with the votes of states' properly appointed electors. Indeed, the Constitution commits to the states the power to appoint presidential electors in such manner as the legislature thereof may direct. Article 2, Section 1's appointments power, we have said, gives the states far-reaching authority over presidential electors, absent some other constitutional constraint. By contrast, the federal government's role in appointing electors is limited. Congress may prescribe when the state-appointed electors shall meet, and it counts and certifies their votes. The president, meanwhile, plays no direct role in the process, nor does he have authority to control the state officials who do. And the framers, wary of cabal, intrigue, and corruption, specifically excluded from service as electors all those who from situation might be suspected of too great devotion to the president in office. Determining whose characterization may be correct, and with respect to which conduct, requires a close analysis of the indictment's extensive and interrelated allegations. Unlike Trump's alleged interactions with the Justice Department, this alleged conduct cannot be neatly categorized as falling within a particular presidential function. The necessary analysis is instead fact-specific, requiring assessment of numerous alleged interactions with a wide variety of state officials and private persons. And the parties' brief comments at oral argument indicate that they starkly disagree on the characterization of these allegations. The concerns we noted at the outset, the expedition of this case, the lack of factual analysis by the lower courts, and the absence of pertinent briefing by the parties, thus become more prominent. We accordingly remand to the district court to determine in the first instance, with the benefit of briefing we lack, whether Trump's conduct in this area qualifies as official or unofficial. 4. Finally, the indictment contains various allegations regarding Trump's conduct in connection with the events of January 6th itself. It alleges that leading up to the January 6th certification proceeding, Trump issued a series of tweets to his nearly 89 million followers, encouraging his supporters to travel to Washington, D.C. on that day. Trump and his co-conspirators addressed the gathered public that morning, asserting that certain states wanted to recertify their electoral votes, and that the vice president had the power to send those states' ballots back for recertification. Trump then allegedly directed the crowd in front of him to go to the Capitol to pressure the vice president to do so at the certification proceeding. When it became public that the vice president would not use his role at the certification proceeding to determine which electoral votes should be counted, the crowd gathered at the Capitol broke through barriers cordoning off the Capitol grounds and eventually broke into the building. The alleged conduct largely consists of Trump's communications in the form of tweets and a public address. The president possesses extraordinary power to speak to his fellow citizens and on their behalf. As the sole person charged by the Constitution with executing the laws of the United States, the president oversees, and thus will frequently speak publicly about, a vast array of activities that touch on nearly every aspect of American life. Indeed, a long-recognized aspect of presidential power is using the office's bully pulpit to persuade Americans, including by speaking forcefully or critically in ways that the president believes would advance the public interest. He is even expected to comment on those matters of public concern that may not directly implicate the activities of the federal government. For instance, to comfort the nation in the wake of an emergency or tragedy. For these reasons, most of a president's public communications are likely to fall comfortably within the outer perimeter of his official responsibilities. There may, however, be contexts in which the president, notwithstanding the prominence of his position, speaks in an unofficial capacity, perhaps as a candidate for office or party leader. To the extent that may be the case, objective analysis of content, form, and context will necessarily inform the inquiry. But there is not always a clear line between the president's personal and official affairs. The analysis, therefore, must be fact-specific and may prove to be challenging. The indictment reflects these challenges. It includes only select tweets and brief snippets of the speech Trump delivered on the morning of January 6th, omitting its full text or context. Whether the tweets, that speech, and Trump's other communications on January 6th involve official conduct may depend on the content and context of each. Knowing, for instance, what else was said contemporaneous to the excerpted communications, or who was involved in transmitting the electronic communications and in organizing the rally, could be relevant to the classification of each communication. This necessarily fact-bound analysis is best performed initially by the district court. We therefore remand to the district court to determine in the first instance whether this alleged conduct is official or unofficial. We've come to the end of episode 3, and we're leaving off on page 30. Next episode, we will pick up on page 30 again with section C. Now remember, this is the section, part 3, section C, in which Justice Barrett did not concur. Until next episode, thanks for listening to What SCOTUS Wrote Us.